Item 35.
Item 35, first matter, I am appearing for the petitioner. But in this case, for the proviso appended to Rule 15 of the Odisha Elementary Education Cadre Service Rule 1999, Amendment Rule of 1999, and 11 is under challenge. Where under?
Why these you are challenging?
Yes, madam. Virus of the rule is under challenge.
Not virus.
Virus of the rule.
Virus. Yes. May I? So according to you, it contains a virus.
Virus. Solely on the ground that it is suffers from legislative incompetency. And second, it also
But they do not have the power under Article 309 or the 162 of the Constitution.
Because the RCFC Act, which came into force with effect from 1/4/2010, clearly mandated that in case of relaxation of qualification, it is the central government to bring relaxation on the request of the state government and by way of a notification. But here what has happened is a central government, by way of amending the RCFC Act in the year
this RCFC,
right to free and compulsory education act, in short,
to the children.
Yes, ma'am.
So now the innovated form is 2009.
But to save the time,
We call it a right to education. Yes, a right to education. Yes. Then
under the said act, the amendment was made in the year 2017, mandating that the qualification as prescribed by the NCT, who is the prescribed authority, is required to be acquired by teachers in position by 4 years, which will be given effect to from 2015 to up to 31st March 2019. By 31st March 2019, initially it was 5 years relaxation, 4 years it was added. By the end of 31st March 2019, each teacher in position is required to acquire the qualification prescribed. Qualification is for the class 1 to 5, higher secondary course or training plus OTT pass. And in respect of upper primary 6th and 7th and 8th, up to 8th, that the qualification is BA, academic qualification, graduation, plus training qualification, plus also OTT pass. Well, what happened? By this amendment is governing the field, state government in exercise of under power provided to 309, Article 309, brought an amendment to the Odisha Elementary Cadre Service Condition Rules of 1997, clearly incorporating that teachers, those who are appointed prior to 2011 to 2011, they are not required to pass the OTT manner. And that exemption, by using the word exempted, they are exempted from acquiring the OTT qualification. Such a exemption provision has been brought by way of in exercise under provision to 309 is contrary to that mandate of the RCFC Act. And also the rules which are framed under RCFC
the point which struck in my mind is, then can you vary the condition of service after the service has commenced? If the service condition at the time of an appointment postulates that these are the things which is there, can you vary the service conditions? Subsequent.
But my humble submission is, even the RT Act has taken care of it.
Can it be varied?
But the Act has already taken care of it. 5 years relaxation was initially granted when it was enacted, madam. And that was extended plus 4 years. That is by 31st March 2019. The Act said so, and the rules framed under the RT Act in 2010, my lord, clear provisions are there. In case of hardship, then state government is to, or Union Territory state government is to make an approach the central government for relaxation of any of the qualifications if the teachers have not acquired that. On their request, it was extended twice, and finally it was extended to 31st March 2019. And the procedure that is under Rule 17, 18 and 19, that makes it clear, upon the request of the state government, central government is to examine it and relax manner. Relaxation word is there, not the exemption which bears in the impugned order, impugned portions of the exemption under the amendment.
What is the distinction or difference between a relaxation and the exemption?
Exemption is for all time to come, exempted from the particular qualification.
Relaxation, according to you, is a on-time measure.
Yes, madam. For a particular period, they have to acquire within that period. They have to acquire the minimum qualification under the RT Act.
It is said to be an extension of time. Why?
Yes, extension of time. Relaxation is an extension of
time. It will
time.
be termed as a relaxation.
Well, the RT Act used consciously in its wisdom, the legislature has used while enacting the RT Act the word relaxation. No exemption word is used there.
That is why I'm so trying, because there are some other judgments are hovering in my mind on relaxation. That is what I'm asking. That what is the intention? You will find the series of lot of judgments, even of a Supreme Court has come, where the authority, while making a recruitment to a particular business, have earmarked the particular age, and the power of relaxation of the age is also given. So, if it is the power to relax the age barrier is also provided, that means that if they have said the candidate must be between the age of, say, 18 to 25, then the power of relaxation is given. The authority has said no, from 25, 30 up to 30 to 10. Given. So, this can't be said to be of a very temporary nature to operate, because it gives a relaxation to those who are entitled for all time to come. Later on, he cannot say that since you were overaged, relaxation has no meaning. There it says that it's a relaxation for the time being given to us. Exemption is perennial in nature.
Yes, madam. Exemption is
Perennial in nature. Whoever irrespective of any criteria, prior or later, they are exempted. This is not a case. This is really an exemption, what we are saying. It is really a relaxation which has to be construed. Nomenclature does not decide it. The substance has to be noted. You are aware of those line of judgment? Nomenclature of an application or a nomenclature of anything is not a determinant factor. The court must look into the substance and find out what is the real intention. So relaxation is permissible. So we have to look at the provision whether it is a relaxation or an exemption.
Here they have, if you are exemption. It is exemption. Clearly, it is exemption.
For all candidates.
No, it is the for teachers, those who are appointed prior to 11 February.
This is really relaxation.
Yes.
But any teacher after that, he has to pass.
Yes.
That is my humble submission before Lordship. Here, the Lordship will find the Act makes a provision
when it came.
Let me place the provision, man.
I think that 15 or 13.
2009 came into force with effect from 1st April 2008.
Anybody who is appointed after 2009, if there is a NCT guidelines, there is a mandate, they have to follow it. They cannot go for an exemption, even a relaxations, they have to.
But when the apex court decision is there, the apex court has held that the NCT guidelines should be followed in the throughout area.
We know.
Yes, that's why this prescribed.
No, the prescribed criteria for NCT.
Yes.
Is to be followed.
But that is a mandatory. OTT.
This is mandatory.
We are not concerned with this. We are now concerned with the bias.
My humble this situation arose in different states, and even in the state of Bihar, rendered the judgment no OTT is compulsory. They have to pass. That was challenged before the Honorable Apex Court. That judgment was confirmed.
It is one thing. But to held a particular law, ultra virus is something else. Please consider. You are arguing an ultra virus. You should know that when the court can declare a legislative action of the
ultra virus.
The
first of all,
the legislative authority. To be, there are 4 or 5 principles.
Yes, madam. P. Krishnamurthy judgment, my lord, and other judgment also, recently.
The judgments are very, very simple. Last judgment, which I know about, is Justice D.Y. Chandrachud's judgment.
Gaurav Kumar, my lord. In case of Advocates Act, it was laid down, man.
Yeah, this lordship with them. That was the decision, man. That first thing is, it is against the constitution provision, any of the constitutional provisions.
Yes, madam.
It is against or infringing the fundamental rights of the parties, which cannot be undermined in the business court. And the third one is that if there is no power which is conferred upon the legislative authorities, or it does not come within the state test of the 7th schedule of the Constitution, yet the law is made, then it is beyond the competence of the state to make a law.
Yes, ma'am.
The fourth one is the law has its operation beyond the territorial boundaries of the state. Then the law can also be declared as, I'm talking about the state. Then in case of a subordinate legislation, it is against the parent, any provision of
yes,
the parent act.
Yes, ma'am. That is clear.
In absence of any rule-making power, the rules are made. These are the
basic ingredient.
Broad principles on which, and then the question of reasonability, test of reasonability, all these things may also come.
My humble submission is, all those criteria are available in this case. First of all, the
legislature, a single is spared. Not even a single instance is spared.
But if I will face my lord,
incidence is spared in your case. Yeah, all the grounds are there.
First ground.
Yeah, at least one ground. Don't take all the ground. What is this?
Alert in second sub-item. I had filed an application for intervention. There is a nothing that
222.
I am filing it. Also, consider it and allow that. I am the beneficiary of the amendment.
The improved provisions.
Then you are a necessary party.
I am in read petition number 21.
Who is there in your writ where you are filed an
Yes, I am for setting the second sub-item. The second sub-item. For the Jena. Yes,
necessary party.
yes, they have given the copy.
They are not necessary parties because every decision would affect their rights. They are the beneficiaries under that particular amendment.
Here the sum.
They are entitled to be treated as a party. Or the right of hearing is there.
Here, in this case, a batch of non-OTT candidates, underqualified candidate intervened, they have been entertained, they have been allowed to file their response, and we have also been allowed to file our reply. That we have done. The matter was hard in length. it was reserved for judgment. Again, it was released. But because of
another division bench. The earlier one.
Erstwhile, interest is retired.
Interest is
Matter
Automatically it goes.
yes, madam.
Difference of regime.
17th January 2025, it was there. Madam,
Which I
IS 75575.
WA number.
WA 17780.
yes,
Second, bear it.
yes, right permission. To the item 35, this was matter WPC number 35836 of 2023. It is not related to this issue, Your Worship. It is not related to this issue. It has to be delisted. 35836 of 2023.
Which are telling for the others.
State is
I'm
there.
there.
State is there.
Is it?
I have not gone through. I rely on the statement.
If it come on that day, you just renew.
Item 36.
Wait for that.
With your Lordship's permission, Millets, I beg to appear virtually, Millets, in this matter, Millets.